Legal concept, international law. There are two branches of law which use the terminology international law. Public international law or the law of nations and private international law, also known as conflict of laws. Public international law. Public international law consists of the rules acknowledged by the general body of civilized independent states to be binding upon them in their mutual relations. This is by Birkenhead. According to Salmond, public international law is essentially a species of conventional law and has its source in international agreements. It consists of those rules which sovereign states have agreed to observe in their dealings with one another. Thus, public international law is that body of rules which regulates the relations between different states as also between individuals and states. Rules of international law have developed as a result of international conferences, multilateral treaties, decisions of international tribunals, opinions and writings of eminent jurists, etc. According to Dr. Setna, international law is all that body of customs, usages, conventions, and principles of international propriety and natural justice as have been accepted or recognized by the nations in the world. There is an interesting controversy on whether public international law can really be called law. Austin and his followers do not consider it as law proper because, in their opinion, there is no sanction behind such law. Perhaps the only sanction is international opinion, and according to the Austinians, this is not sufficient for the purpose of enforcement of law. Modern jurists are, however, of the opinion that the law need not necessarily have the sanction or force as one of its features. They feel that restraint is not an important element of any law, though it is a powerful characteristic of law. They agree that today international censure is a more powerful weapon than the sanction which underlies the civil law. Private international law. Private international law, also referred to as conflict of laws, is a totally different subject. It deals mainly with the cases of private individuals where a foreign element is involved. Thus, a trader from India sells his goods to a trader in France, the delivery to be effected in Germany, and the money to be paid in Italy. In case of a breach of contract, a question may arise as to whether a suit may be filed in India or in France or in Germany or in Italy. After that question is answered, the next question would be which of the four legal systems would apply. Additionally, if the same two traders have already litigated earlier, a further question would arise as regards the recognition and enforcement of the earlier judgment. Thus, the three primary questions before the court in a case involving private international law are: 1. Choice of jurisdiction, that is, which court has the jurisdiction to try the case. 2. Choice of law, that is, which law should the court apply. And 3. Recognition and enforcement of foreign judgments.